Do we have anyone who is not a law student or a lawyer? So some with no legal background? Okay, that's helpful. What I want to do is tell you about some stuff that has been happening in the anti-doping world in Australia in the last few years. And for those who aren't familiar with that area, these are the terms that we'll come across. People have heard of WADA. There was a bit of WADA talk earlier today. The World Anti-Doping Agency Code. ASADA is the national body in Australia that is the National Anti-Doping Organisation. So it's responsible for investigating and prosecuting matters involving the WADA code. Do you all remember just on 5 years ago, the darkest day in Australian sport? Some of you are perhaps too young to remember that the heads of the various large sports in Australia called to Canberra. I think it was the Justice Minister and the Sports Minister, someone from the Australian Crime Commission is there, and they talked about how organised crime was infiltrating sport. Does everyone sort of have a vague memory of that? Well, the next day, a bill was introduced into the Commonwealth Parliament, and that bill was to amend the ASADA Act and to give ASADA greater teeth to increase its coercive powers. Up until then, ASADA was saying that it didn't really have the investigative teeth to compel people to cooperate in their investigations. They'd go and speak to athletes. Sometimes they couldn't even speak to the people they wanted to because those people were not covered by any agreement. They might be the water boy or someone who cleans the boots or someone who sweeps out the change rooms. So ASADA wanted the legislation amended. And one of the things that they wanted to do was to take away, to abrogate, which is the legal word, several common law privileges. And before we go to have a look at what happened in the legislation, we just need a little refresher course about the law against self-incrimination. Now, you've all watched American TV, you know, it's pleading the fifth, you know, I'm not going to say anything. So the privilege against self-incrimination is deeply ingrained in the common law. The courts say it's not to be taken away unless it is clear that Parliament is intending to do that. So it's a really important common law privilege. The original bill had no carve-out, had no exception in relation to the privilege. So the original bill said that you've got to answer a question, you've got to give information, you've got to produce a document or a thing. You're not excused from doing that, even though it might tend to incriminate you or expose you to a penalty. So that was the bill that went in the day after the blackest day in Australian sport. By August of that year, August 2013, the Act has been amended. And this is what it looks like after it's amended. So just staying with subsection 1, the Act says you are excused from complying with a requirement to answer a question if it would tend to incriminate you. You're not excused from producing a document or a thing. So the mechanism is the CEO of ASADA sends a note that you're required to either turn up and answer questions or turn up and give information, not quite sure what the difference is, or to produce a thing or a document. And originally, the bill said privilege didn't apply to any of those. the way it was enacted, the privilege applies to the answering a question. The rationale might be that the notice to produce a document or a thing is a bit like a subpoena. But that's what the Commonwealth Parliament did. So ASADA did not get all of the powers that it wanted. It's a bit like ASADA went along and said, give us X, Y and Z, and Parliament said, we'll give you X and Y, but we're not going to give you Z. So what do you think ASADA did? What might ASADA have done? Try and get it some other way? All right, well, before we work out what ASADA did, what is ASADA? This is from ASADA's website. It is our national anti-doping organisation, and we set out to implement a program consistent with, amongst other things, Australian legislation. And that would appear to make sense, that ASADA, amongst other things, has to do things that are consistent with Australian legislation. What happened was the template that ASADA produces for sports to use in their anti-doping policy was amended to add a new Article 6A. So this is a template that athletes are handed by their sporting organisations, and as part of their contractual agreement agree to be bound by the policy. So the new article says anyone who's bound by this policy has to assist, cooperate and liaise with ASADA to do those three things that we've already seen was in the bill and the Act. So the new article gives to ASADA and to the sporting bodies what the legislative provision does not. Can everyone see that? So the Act said the privilege exists in relation to A, attending the interview. This policy is drawn so that the athlete contractually gives away the privilege against self-incrimination and the privilege against self-exposure to a penalty. Now, we can have an interesting philosophical decision and discussion about whether athletes ought to be required to give away these common law rights. If someone is charged with shoplifting from a supermarket this afternoon, they enjoy a number of common law privileges. One of them is the privilege against self-incrimination, the right to silence. If someone is charged with murder this afternoon, they enjoy the same privilege. Ought athletes be required to give it away? You know, the reality is if you don't sign these contracts and sign up for these policies, you don't play. You know, the 18-year-old kid turns up and says, I want to swim for Australia, where do I sign? And they sign a contract and agree to be bound by a whole lot of stuff: social media policy, anti-doping policy, racial discrimination policy, a whole raft of things. So, this policy is amended. The template is amended and is distributed to the various sports, and they insert their name, whether it, you know, Swimming Australia or Athletics Australia or Netball Australia, whatever sport you want to put there. and they give it to their athletes, and that is part of the contractual agreement. Now, the preface to this document is the next slide. So when you're handed the policy, if you bothered to read it, this is what you would see in the preface. Now, does that preface look as though it is saying that this policy is consistent with, amongst other things, the ASADA Act? No, it's not, is it? I've shown you what the Act says, the privileges retained in a situation. I've shown you that the template takes it away. And later in the preface, that's what the reader of the preface is told. The objectives of this policy are, amongst other things, to comply with the Act. I think there's an argument that the policy doesn't comply with the Act or is inconsistent with the Act. Now, what I've just told you is not new. Might be new to some of you, but it's not new to the public domain. It's been known publicly since November 2015, when this was revealed at a sports law conference and subsequently in the Australian New Zealand Sports Law Journal. Tracy Holmes, the ABC sports commentator, ran a series of stories on it, in which she essentially reported what I've just shown you, that the bill went in, ASADA wanted X, Y and Z, ASADA got X and Y and got Z contractually by inserting a new article in the template. So the story went to air like that, and this is what ASADA said in response. And this was broadcast during one of Tracy Holmes' programs. Any reaction to that when you read that that's ASADA's response to this being discussed in the public? What does anyone think of the ASADA response? The clue is in the bit that's in red.
Seems like a deflection somewhere.
Yeah. What's the Australian Olympic Committee? What are they responsible for? Yeah. This template is distributed to or made available to Olympic and non-Olympic sports. ASADA is an independent statutory Commonwealth body funded by Commonwealth money. What's it doing following the request and directions of the AOC? That's an extract from the anti-doping bylaw of the AOC. Number of you are smiling. Do you think that the what is revealed on that slide might be said to be somewhat of an interference with operational decisions or activities? ASADA released a media statement in those or including those terms. Now that is strictly correct. The contractual agreement is not between the athlete and ASADA. It's between the National Sporting Organisation. My 18-year-old swimmer who wants to swim for Australia signs an agreement between Swimming Australia and themselves. But the anti-doping policy that is going to be part of that contractual arrangement has been drawn by ASADA and provided to Olympic and non-Olympic sports. It appears to have been amended at the request of the AOC. Interestingly, back in 2005, it would seem the AOC had a different view about the privilege. It would seem that in 2005, the AOC accepts that there's a balancing exercise and that you can achieve that balance by maintaining that privilege in particular ways. And yet, it would seem by 2013 and subsequently, they have a different view. John Coates, the president of the AOC, was interviewed by Tracy Holmes. The next slide is a portion of what he said. Okay, so that position is clean athletes have got nothing to worry about. We as a community accept that in certain situations you have to answer questions. And if it's good enough for ASIC in regulating the financial markets to compel people to answer questions, it ought to be good enough for athletes. The Australian Taxation Office, liquidators, people involved in bankruptcy proceedings, various bodies and individuals can compel someone to come and answer questions. And the reason they can do that is Parliament has given the Tax Office, the trustee in bankruptcy, the liquidator of a company, the powers to do that. So with great respect, to draw the analogy that is on the screen misses the point. The reason ASIC can do that is because they have been expressly given those statutory powers. So why does any of this matter? What is a Commonwealth body who goes to the Commonwealth Parliament to get the power to do X, Y and Z and only gets the power to do X and Y? Why are they then attempting to get the power to do Z through a contractual arrangement where no one is not going to sign up for? If you want to swim for Australia, you have to sign up. And why is the preface to the template in the way it is? Now, if the preface was there by mistake, in the sense that no one went back to look at the preface after the new article went in, that's a very reasonable and likely explanation. But this has now been in the public domain for 2.25 years. There are hundreds of athletes coming up to this part of the country in 6 or 8 weeks' time who will have signed up with their national sporting organisations and agreed to be bound by this anti-doping policy, and the documents they have signed have the preface as I have shown it to you today. So what's happened in the last 2 years? Where are the national sporting organisations saying to their athletes, well, we actually need to change the preface to this policy and we need to make sure the athletes know that what they're signing up for actually is more than the Commonwealth Parliament thought was necessary. Now, they probably can give away contractually these rights, but let's do it in a transparent fashion. This is all about good governance, integrity, clean sport, clean athletes. And there's a lot said about the way athletes behave on and off the field, how they conduct themselves in their social lives, what they put on social media, the expectations of them. Where are the athlete associations in the last year? None of the sports that are competing at the Commonwealth Games have a template that has a different preface to what I've put up. This has been in the public domain for 2 years. Why aren't we doing anything about it? I'm not for a moment questioning the importance of clean or fair sport. I'm not suggesting that if this document was changed to make it clear to the athlete that this is what they were giving away, they wouldn't sign it. And they probably would. I want to swim for Australia. Where do I sign? It's about the rule of law. Parliament has created a set of rules. Are we satisfied about the manner in which they've been altered? Are you? This is a place to point out what has happened. Ought Commonwealth agencies be trying to get contractually what Parliament wouldn't give them? And if you're going to do it, why aren't you being completely upfront and transparent about what you're doing? After all, we're in the world of integrity and governance. That's the space we're in. Why aren't we making it absolutely clear what we're doing? So I think we end up with common ground, Keith.